Madam Deputy Registrar, can you please commence proceedings?
Thank you, President Saunders. Caribbean Court of Justice, appellate jurisdiction on appeal from the Court of Appeal of Belize, judgment delivery in BZCV number 4 of 2023 between Insurance Corporation of Belize Limited and Kahtal Resorts International Limited. The members of the delivery panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, everyone.
Madam Justice Rajnath-Lee.
Good morning, all.
Mr. Justice Barrow.
Good morning, Counsel.
Mr. Justice Burgess.
Good morning, Counsel.
And Mr. Justice Jamajal.
Good day, everyone.
May we have the appearances, please? Thank you.
Darrell Bradley, together with Miss Julianne Ellis Bradley, appearing for the Insurance Corporation of Belize.
May it please your honors, Magali Marignon, together with Alistair Jenkins for the respondent, Kahtal Resorts International Limited. Sorry.
Yes, thank you. Well, in this case, the court is divided. Ultimately, 3 judges have agreed to have the appeal dismissed, and the lead judgment was written by Mr. Justice Burgess. I will ask him to read a summary of that judgment.
Thank you so very much, Mr. President. This summary is not intended to be a substitute for the reasons of the Caribbean Court of Justice, or to be used in any later consideration of the court's reasons. This is an appeal from the Court of Appeal of Belize. In it, the respondent, Kahtal Resorts International Limited, sought to bring a claim under an insurance policy against the Appellant, Insurance Corporation of Belize Limited, for damage sustained to the respondent's parasailing boat during a thunderstorm. The marine vessel sunk while in dock, afloat at Tom's Boatyard, San Pedro, Belize, and it sustained damage having been submerged in the water. The vessel was insured by the appellant under a written insurance policy. The policy contained 12 pages with a section on quote-unquote definitions used in this policy. The definition section does not, however, define in dock, nor does it define moored. The policy also contains a section entitled quote-unquote Section 1, coverage, your property, property insured, and reads in the relevant parts as follows. We insure your vessel, machinery, and equipment as described on the declaration page. Peril insured. We will pay for direct physical loss or damage to the property from any external cause, subject to the exclusions and conditions of this policy. The vessel is covered subject to the provisions of this insurance while in commission at sea or inland water, or in port, docks, marinas, on-way, pontoons, or at a place of storage ashore. Exclusions. No claim shall be allowed in respect of exclusion 15, loss or damage while vessel is moored unless such loss or damage results from collision with another vessel. The appellant denied liability based on exclusion clause 15. In the High Court, the trial judge found in favor of the appellant that based on the interpretation of the word moored, exclusion clause 15 applied and the respondent was not allowed to claim. The respondent thereafter appealed to the Court of Appeal. The Court of Appeal examined the strict meaning of moored and held that Exclusion Clause 15 was inapplicable because when in dock, the vessel could not be considered moored within the strict meaning of that word, and thus that the trial judge had erred. The appellant appealed to this court. The judgment of the CCJ was delivered by Justice Burgess. He applied the objective and contextual approach to interpretation of commercial contracts as outlined in Blairmont Rice Investments Incorporated and Cayman Sankar Company Limited. So Justice Burgess considered three background contexts: the factual matrix, the contractual context, and the textual context. Following this analysis, Mr. Justice Burgess held that the term moored in the exclusion clause should be given a technical meaning. He opined that the ordinary meaning would lead to the absurdity of removing the very indemnity the insurance policy seeks to provide. The reasonable businessman would not find such a result to make commercial sense. Mr. Justice Burgess therefore concluded that moored did not include being in dock. Interpreting the exclusion clause more restrictively, he found in favor of the respondent. Mr. Justice Jamadar agreed with the reasoning of Mr. Justice Burgess, and in a concurring judgment, discussed the contra profferentum rule, suggesting its potential application in the event of any ambiguity in the exclusion clause. Mr. Justice Jamadar emphasized that the contra profferentum rule, rooted in fairness and equality, applies to ambiguous contract terms. He noted that in the modern context, there has been a shift away from a default reliance on the rule, especially in cases where the parties are of equal bargaining power. However, its importance remains in insurance contracts, which are often pre-written, containing technical terms, and where the parties are of unequal bargaining power. Mr. Justice Jamadar cited the need for clarity in exclusion clauses like Exclusion Clause 15. Mr. Justice Jamadar highlighted the importance of good faith in insurance contracts, drawing reference to this court's approach in Sandy Lane Hotel and Juliana Cato and Apsarak Restaurants, Barbados Limited, and Guardian General Insurance, as well as the approaches of the Indian and Australian courts. Mr. Justice Jamadar deduced that the good faith principle was an underlying concept implied into certain contracts. He opined that the principle of good faith, coupled with the contra profferentum rule, necessitates fairness, precision, and clarity in drafting, especially in standard form contracts with unequal bargaining power. Mr. Justice Barrow dissented. Upon examining the practice in the marine insurance industry, he concluded that the exclusion clause was intended to cover stationary vessels, irrespective of the terms moored or in dock. Thus, in his view, the Court of Appeal misinterpreted the policy's intention, and the exclusion clause clearly applied to stationary vessels in dock. The court, by a majority of 3-2, upheld the decision of the Court of Appeal and dismissed the claim. Mr. President, as I understand it, the order on cost is to be declared by the court, and I will leave that in your good hand, Mr. President.
Sure.
This is a summary of the case. Thank you very much, Mr. President.
Yes, thank you, Justice Burgess. And for the sake of clarity and the avoidance of doubt, I concurred with the dissenting view that was authored by Justice Barrow. Now, my understanding is that the parties have not been able to agree costs. Is that correct?
That is correct,
That is correct.
Mr. President.
Well, listen, we are very reluctant to prolong litigation and have parties and either the bench or the registrar have to have this another time around. Were costs agreed or settled in the courts below?
They were. Prior to the issue of the High Court decision and the Court of Appeal, the parties agreed to a fixed sum before.
So
It's only in relation.
why can't the parties agree to a fixed sum now?
We believe we can.
Yeah.
Your Honor, if we may, Mr. Jenkins would like to clarify what happened in the court, the first instance court and the Court of Appeal as the costs.
Yes. Good morning, Mr. President. The cost that were agreed was $20,000, but only in relation to the preliminary issue. So this appeal is only in relation to the preliminary issue. The issue of damages is still outstanding.
No. But was that
So the 20,000 was only in relation to the preliminary
at the
issue
Court of Appeal?
at the Supreme Court level.
Okay, and then at the Court of Appeal?
We did not have we agreed on 24,000, I believe.
So
Sorry, Councillor, excuse me. I thought, I do not have it presently before me, I thought I saw in the Court of Appeal's judgment a specific statement that it was awarding the cost as agreed in the sum of, I think, 20,000. Am I wrong
Yes.
or correct?
That is correct. That is for the court below, but not
No,
in
the
relation-
Court of Appeal, the Court of Appeal.
No, it was on the 20,000 was agreed in the Supreme Court proceedings, not the Court of Appeal.
The Court of Appeal's judgment states something in relation to costs. Please
Yes,
remind me what it says.
It says $20,000 in the court below and costs in the appeal. So the $20,000 was in relation to the Supreme Court proceedings, not in the Court of Appeal. We agreed on separate costs in relation to the Court of Appeal proceedings.
And that was agreed in the Court of Appeal. Subsequent to the pronouncement of the judgment,
That is
the
correct.
costs were agreed.
Correct.
Okay, thank you.
so that you already have an agreed figure for the Supreme Court's proceedings and an agreed figure for
Correct.
the appeal court's proceedings.
That is correct, Your Honor.
You're not currently in the same location.
No, Your Honor. Unfortunately, the offer was far from what we had agreed in both courts below. And so we could not accept the offer that was made to us yesterday.
You'll need to try harder.
Yes, Your Honor. Mr. President, we're prepared to make the same offer that was agreed in the Court of Appeal.
Yeah, what's wrong with that?
Your Honor, we would have to take instructions from our client. That's just being given just now. Up until this morning, what was offered was far below that sum. So if the court is minded to give us, I would say 5 minutes, we could take instructions, Your Honor. And if that is agreeable, then we will accept those.
Sure, we will give you the 5 minutes so you could take instructions. But it seems to me the same points were re-argued before this court. I can't see that the effort was any greater than was made at the court below, at the Court of Appeal. So by all means, go ahead and take instructions. We will come back at 1:20. Yes. Ms. Magali Young, do you have any news for us?
Your Honor, our client is prepared to accept the same cost that was agreed to in the Court of Appeal.
Great. So the formal order, which will be sent to you in due course, is that the appeal is dismissed and costs are agreed in, what is that precise sum, Mr. Bradley?
That figure was $24,000.
Costs are agreed in the sum of $24,000. Is there anything else?
No,
No?
Mr. President, not from the appellant.
Not from the respondent of Your Honors.
Okay, thank you. In that case, it only is left for me to wish you all a pleasant good afternoon. All the best to you. Madam Deputy Registrar, can you please close the proceedings?
Thank you, President Saunders. Thank you, Madam Justice Rochnotly. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Bridges. And thank you, Mr. Justice Jamala. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. Do have a wonderful, safe weekend. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.